Hello everyone, welcome to week 4 of administrative law. This week we'll be looking at the broad framework for the judicial review process. And in particular, something that we're going to really focus on is the availability of judicial review. So if we have a look at our sort of roadmap for the course as a whole, in previous weeks we've looked at how we might access information to find out the reasons behind a decision and to access government documents more broadly. And then last week we talked about merits review as an avenue for reviewing a decision that takes into account both questions of fact and questions of law. It's quite a compact little process, which is why we only needed a week to cover it. But what's really great about it is that, as we talked about, it's a bit cheaper, it's usually a little bit quicker, and the decision makers are empowered to, subject to legislation, make the decision again and to substitute the correct and preferable decision for the decision that was made in the beginning. The disadvantage of merits review is that it relies on specific legislation enabling a body like the Administrative Appeals Tribunal to engage in a merits review process. So it's not always an option to go through merits review. And in that case, we need to look at judicial review and need to look at the courts having a look at the decision and perhaps overturning it if need be. So for the remainder of this unit, we're really going to focus on the judicial review process. And that starts with this week, where we look at the availability of judicial review. We'll start by taking a bit more of a detailed look at what is judicial review, and then we'll look at the circumstances under which we can ask the court to have a look at an administrative decision. So we'll start off today's video with a quick recap on the difference between judicial and merits review, and then I'll provide a broad roadmap for judicial review. Then we'll look at three factors that influence the availability of judicial review, and I'll actually break those up into 3 different videos. So jurisdiction I'll tag on to the end of this video, but then justiciability and standing will be their own videos, just to break up the recordings into sort of more manageable sessions. So let's start off with a quick recap of merits review and judicial review. We talked a lot about this last week, so I won't go into too much detail, but you'll remember that merits review can examine questions of fact and questions of law, whereas judicial review is only interested in questions of law. So really what we're focused on here for the rest of the unit is a procedural question of whether the law was followed, whether the requirements of an act were followed, whether the decision maker complied with all the requirements that were asked of them, and things like that. We're not too interested for the rest of the course on the content of the decision itself or the findings of fact that underpin that decision. There's a couple of exceptions that we'll talk about in a couple of weeks' time, but in a broad sense, when we're interested only in questions of law and questions of procedure. So in order for judicial review to go ahead, in order for a court to be willing to take a look at an administrative decision and be prepared to set it aside, we've got to meet a couple of really important steps along the way. So the first thing is that judicial review must be available, and that's what we'll talk about today. You've got to have jurisdiction. So you have to identify the right court to hear that matter. Usually that's a matter of determining whether this is Commonwealth or state legislation. And as you know, in this unit, we're really focused on the Commonwealth. Justiciability, which is whether the court is empowered to review a particular decision. Not all decisions of an administrative character will be reviewable. And so we'll take a bit of time to look at, okay, well, what are the decisions that a court is interested in reviewing? And thirdly, an applicant has to have standing. They have to have some special interest or connection with the decision in order to ask the court to review it. So if we can meet those 3 requirements, then judicial review will be available to us, which is great. Then we need a ground of review. We need a problem, an error of law that will enable the court to say there was a problem with this that needs to be addressed. And so we'll spend a fair bit of time over the next few weeks looking at different grounds of review, different problems with a decision, different errors of law that would open up a decision to review by the courts. And then lastly, there needs to be some kind of remedy available. And those can be provided by statute or via common law or equity. It is important to keep in mind that the remedies available are much narrower than those under merits review. And so that is something that needs to be borne in mind throughout the judicial review process, is that ultimately, best case scenario here, we've got the court setting aside a decision. A court can never substitute its own decision for the decision that was made by the original decision maker. So best case scenario, we're asking for the court to quash a decision or set it aside or put an injunction in place or something like that. So, but there has to be a remedy available. A court's not going to be interested in reviewing a decision if there's going to be no point at the end of the day. So a remedy that is available and workable under the circumstances is itself an important requirement along the judicial review process. So availability will be today, grounds of review next few weeks, and then remedy in week 11. And once we can tick all those boxes, then we can say that a judicial review is available to us, and then we can go down that path. So let's talk about availability, and I'll wrap up this video by talking about jurisdiction. And the first thing we need to do is distinguish between Commonwealth or state and territory jurisdiction. So obviously, if a decision is made under Commonwealth legislation, then it's Commonwealth jurisdiction. We're looking at the Federal Circuit Court or the Federal Court, or maybe even the High Court to review that decision. If a decision is made under state law, we're looking through perhaps magistrate, district or Supreme Courts in the different states. But in this unit, we're really focused on the Commonwealth jurisdiction because we're a nationwide university. We need this to be sort of applicable to anyone, no matter what state or territory they're studying in. So we're focusing on the Commonwealth for now. But it is important to keep in mind that there is that distinction. Within the Commonwealth, the High Court has original jurisdiction under Section 75, but for the most part, we'll be targeting the Federal Court for judicial review. And under Section 8 of the Administrative Decisions Judicial Review Act and Section 39B and 44 of the Judiciary Act, these are the provisions that really allow for judicial review within the Federal Court. The Federal Circuit Court has, formerly the Federal Magistrates Court, has the same jurisdiction as the Federal Court, but it's less extensive. The Federal Court has greater scope to hear matters and to engage in judicial review. So for this unit, I really want you to be thinking about the Federal Court as being the court with jurisdiction, the court that we'll be going to for judicial review. I'll leave this video there. I'll try and keep these 3 videos nice and brief so that they're easy to refer back to. We'll come back in the second video to talk about justiciability, which is the appropriateness of judicial review. And then in the third video, we'll talk about standing. So I'll see you then. Thanks very much.